Hello and welcome to this information session on unfair dismissals and general protections. David, can you tell us what a dismissal is?
Fiona, you're dismissed if you're dismissed at the initiative of your employer. That is to say, the employment would have continued but for a decision by the employer to say, Fiona, go, you're out of here. There are scenarios where you could make that election, what we call the push and jump scenario, where an employer would say to you, Fiona, unless you resign, I'm going to terminate you. Now, that's technically you've resigned, but in those circumstances it was an exercise of your free will. That was very much at the employer's initiative. So it's when the employer says to the employee, you must go.
So when can a person be unfairly dismissed?
Well, a dismissal is unfair if it occurs in circumstances that are described as harsh, unjust or unreasonable. That is to say, if there is something unfair or unreasonable about the explanation the employer had for requiring the employee to go. That can be arising out of the circumstances itself, or it can be because the employer hasn't provided a fair process. If an allegation is to be made against an employee, then it's reasonable for the employee to be told what it is that's in the employer's mind and have an opportunity to respond and say, look, no, I think that's wrong, or to provide some other explanation as to why the employer may have misunderstood the situation. It will obviously be relevant that an employee has or hasn't misbehaved in the past, and it might be relevant that there are or are not warnings on that employee's file which would justify the employer taking a more serious view. Obviously, some reasons which justify the termination of an employee, some things can be so serious that they would justify termination straight away, a very serious safety breach or a serious assault on another employee, something like that. But other matters such as absenteeism or turning up late whilst they're breaches of the employment relationship aren't something which are so serious that you'd expect to be terminated just because that happened. And in those circumstances, whether there has been an appropriate warning process, all of those things will turn on whether the termination of the employment at that moment has been unfair, whether it's been harsh, unjust or unreasonable.
And who can make an unfair dismissal claim?
Basically, any employee who has been in the employment for at least 6 months. In the case of small business, that period is 12 months, but for employees, the probation period that we used to have has been replaced by a qualifying period. So in the first 6 months, an employer can terminate an employee without having to face an application for unfair dismissal. But once an employee has been there for 6 months, then they have the right to complain that the termination was unfair. Beyond that, any employee whose employment is covered by a modern award or by an enterprise agreement is entitled to make an application. Award-free employees can make an application, but only if their level of income is at or below $108,300. That figure is adjustable on 1 July each year for CPI, but at the moment $108,300 is the award-free level. Those are the people who are entitled to make an application for unfair dismissal. It's probably worth actually pointing out that one of the difficulties with the old legislation was the arbitrary imposition of a number. And if an employer had 100 or fewer employees, then those employees were not able to make an application for unfair dismissal. One of the features of Fair Work is that it's removed any kind of limit in terms of number. It just simply goes on, have you been there for long enough? Are you covered by an award, or do you earn sufficient level of income to justify a claim?
What are the new regulations for unfair dismissal for small business?
Fiona, unfair dismissal has always been regarded as a bit of a difficulty for small business. I think quite wrongly, because I don't think employers should be afraid of unfair dismissal, provided they understand how to act fairly and decently in employment. But to the extent that it has been an unreasonable impost, the Act has introduced what's called a fair dismissal code. That's, if you like, a self-regulation ticker-box system that an employer can run through and say, yes, I have a valid reason for terminating your employment. Yes, I've explained to you what it is. I've given you an opportunity to respond. And provided all those boxes can be properly ticked, it is a fair dismissal. If the employee feels aggrieved and says, no, there wasn't a valid reason, or no, you didn't go through that process, then the employee is able to object. And in those circumstances, the matter will run through in the ordinary way as if it were just an application for unfair dismissal.
What are general protections?
General protections are a new system of protections for employees which prevent employees from having what's called adverse action taken against them by their employers. Under the old rules, as well as unfair dismissal, which we've just discussed, there was also this idea of unlawful dismissal. That is, if I dismissed you not because of anything to do with your performance or your conduct, but because of your age or because I thought you suffered from an illness or disability, issues which would both be unlawful if that were the reason for my terminating your employment. That unlawful dismissal process is now gone. It's been replaced by the general protection provisions, and it's been broadened out to some extent so that any action I take against you which limits your exercise of a workplace right, for example, your right to appoint a bargaining agent, any action I take against you which is unfairly discriminatory, action I take against you because you belong or refuse to belong to a union, those are all the bases for your making an application under the general protection provisions.
Oh, I see. That's interesting for the employees. And what happens for a company if they breach a general protection?
Much the same as unfair dismissal, the employee or the contractor or presumed contractor is entitled to make application to a body now called Fair Work Australia, replacing the Industrial Relations Commission, for relief. In the case of dismissal, the relief can be, look, I want my job back, so reinstate would be the primary remedy, or failing that, some kind of compensation, and if someone's been denied an opportunity, then compensation which matches in some way the loss that they've suffered as a result of the employer's breach.
Thank you, David.
My pleasure, Fiona.
You can call the Fair Work Information Line for more information on the Fair Work Act and how it affects your business. You can call 1300 10 21 67.